Claudia, lest there be any doubt about who's in charge here, has been immediately eliminated, right? Okay. Good morning. So residents throughout the southeast San Fernando Valley and the Santa Monica Mountains have been up in arms over increased airplane noise with regard to planes departing from Hollywood Burbank Airport, and other impacts too. As you all know, earlier this year, our office sued the Federal Aviation Administration with regard to flights incoming to Los Angeles International Airport. Well, today I'm announcing that this morning we have filed a lawsuit in the United States Circuit Court of Appeal for the Ninth Circuit, in which we are suing the FAA with regard to flights departing from Hollywood Burbank Airport. We're fighting to get relief for tens of thousands of residents and businesses who have borne the brunt of increased noise and other impacts from these flights. And we're urging the court to take a couple different steps. The most important of which is we're urging the court to return these flights to their previous patterns. We have a separate lawsuit we filed today as well, a Freedom of Information Act lawsuit, in which we're urging the court to require the FAA to divulge information regarding these flight patterns and related issues that the public has been entitled to see now for some time. In 2017, the FAA promulgated 2 departure routes from Hollywood Burbank Airport. And those routes were part of what's called the Southern California Metroplex project. The FAA's environmental assessment with regard to that Metroplex project assumed that the flights would be departing using historic flight patterns. But that's not what happened. I'm actually going to read a couple quotes from what the FAA says regarding what really happened. The FAA says, it appears the runway 15 departure tracks, those are the relevant ones, from 2018 shifted slightly south compared to tracks in 2016. The FAA separately said that flight data show a southern shift for the southernmost airport flight tracks that coincides with the time Metroplex procedures were implemented. Southerly shift, different from the historic flight tracks, different from the historic flight tracks on which the environmental analysis was premised when this Metroplex project was first put in place. So in October, you might be aware, I sent a letter to the FAA. In that letter, I demanded the FAA require departing aircraft adhere to the historic flight paths, the flight paths on which the FAA had premised its environmental analysis. And last month, the FAA responded. The FAA's response, well, it wasn't what you call a ringing grant of our request. They didn't grant our request at all. The FAA didn't deny that flights were persistently intruding into new airspace, but instead, the FAA tried to disclaim responsibility altogether. They pointed to everything from weather to plane volume to even to pilot capabilities, but nothing that the FAA did or didn't do. Well, the last time I checked, it was the FAA that controlled our airspace. The last time I checked, it was the FAA that directed all aircraft departing from Hollywood Burbank Airport, or any airport for that matter, included a specific path. And so here we are. The FAA, on our view, is abdicating its responsibility, and we're seeking a court to intervene. But the Court of Appeal to whom we have sought relief, it doesn't need to take just our word for the fact this is the FAA's responsibility. I'm going to read for you a quote from the U.S. Supreme Court. And here's what the Supreme Court said 75 years ago. Planes, the court wrote, don't just wander about in the sky like vagrant clouds. They only move by federal permission and under an intricate system of federal commands. A plane takes off only by instruction from the control tower. It travels on prescribed beams. It may be diverted from its intended landing. It obeys signals and orders. But in this light, I have to say, the FAA's response to us in November signals a stunning lack of accountability and abdication of responsibility. So we've gone to court. And if the FAA won't take responsibility for fixing the problem, we're asking a court to order it to do so. Again, we want the FAA to be ordered by a court to correct the southern shift that was not studied pursuant to the environmental process in the Metroplex system in the first place. I want to mention we filed a separate lawsuit today, I alluded to it earlier. Concurrent with this litigation, we filed a lawsuit in federal court asking a federal court to order the FAA to respond to previous Freedom of Information Act requests regarding these issues. And the two lawsuits do intersect. I'll give you an example. There are a couple ways that are very straightforward in which those Freedom of Information Act requests would relate to this lawsuit. We asked, for example, that the FAA in those requests provide responses to why they took off the table several different alternatives to the Metroplex process. Those might be really very important information now as we examine what ought to happen moving forward. We asked the FAA to provide us with information that would give us baseline data so we can see where the planes exactly were on its analysis and what has happened since. That is going to be really important for us. By the way, we also filed another Freedom of Information Act request just today. Again, a series of efforts to try to extract from the FAA information that it should be providing to the public, concurrent with an effort to get the FAA to restore to historic flight paths the flights departing from Hollywood Burbank Airport because it hasn't done the environmental analysis that would have been the predicate to a change in flight pattern. This has been a very arduous effort because the FAA has been, as you can tell, quite intransigent when it comes to freeing up this information, and obviously the FAA has not been responsive to our requests. So we've been relying very heavily on a team that includes Dave Michelson from our office and Ruth Kwan from our office, with outside counsel involved with us, Peter Kirsch. It's a great team. I'm very, very, very grateful to them for their hard work. And now I want to turn things over to two colleagues in city government who have been very focused on this issue and standing up for the interests of those who have incurred, as I mentioned, such detriment in their lives from this increase in noise and other impacts. And first I'll turn to our colleague, City Council Member Paul Krekorian, who represents the 2nd City Council District. Paul?
Thank you very much, Mr. Feuer. I'm standing here as a resident of the Southeast San Fernando Valley, as the representative in the council of the Southeast San Fernando Valley, and as the vice chair of the multi-jurisdictional task force on airport noise in the San Fernando Valley. And I first want to thank the city attorney for his partnership throughout this effort. It has been a long and arduous path to get to this point. It will continue to be, but this is a fight that's very important to the people of the San Fernando Valley. We know that a sudden and dramatic change occurred in the skies over the valley in 2017. I can tell you as a resident of the valley, I can tell you as a resident of 250,000 people who live there, that this was a noticeable and sudden and dramatic change in the way aircraft noise was being experienced in different neighborhoods in the valley. We responded to that change immediately. The city attorney and I wrote many months ago to the FAA pointing out to them the inadequacy of their review of departure procedures. We then wrote again to the FAA, along with our colleagues, Mr. Koretz and Mr. Rue, asking for further information or some explanation about this dramatic noise increase, again, with no response. The city attorney and I then moved forward with a Freedom of Information Act request. Again, an entirely inadequate response to that very reasonable request from the FAA. When they provided that inadequate response, we responded with an appeal to that, which still was ignored. The airport authority itself, the Hollywood Burbank Airport Authority itself, wrote to the FAA asking for relief from this change, and they were rebuffed. We in the council supported the authority in that effort. And then the FAA created this multi-jurisdictional task force, which Mr. Koretz, Mr. Rue, I, our congressional representatives, our other colleagues in the council all sit on, so that we could begin to develop the facts and information necessary to find resolution to this. And throughout that task force process as well, we've asked pages and pages of questions of the FAA representatives that have gone unanswered. So the stonewalling from the FAA cannot continue. We've experienced this shift in noise personally. Every consultant that has looked at this issue has acknowledged the shift in noise, that flight patterns and therefore the noise has moved southward. At our last task force meeting, the FAA acknowledged that fact and said that according to their data, the flight paths had shifted 1/3 of a mile to the south. But they continue to deny any responsibility for it. They continue to deny any knowledge of how that could have happened. They continue to deny that any change in procedures has been made. But they have no explanation for what they must admit, which is that the noise has dramatically increased in certain areas and the flight patterns have changed. Now, we don't know yet through our work in the task force what resolution will come of this. I can tell you now that one resolution that will not be acceptable to me is to simply move the torture that one neighborhood is experiencing to another neighborhood so that that neighborhood can be tortured. This has been a function of the Metroplex project the city attorney described to narrow the flight departures into a narrower and narrower alley. And that causes a dramatic increase in the neighborhoods that are impacted by that narrow alley. That needs to change. This is not just about moving the flights. We need to relieve these neighborhoods of that over-concentration of flights as well. And we're certainly going to continue to fight within the task force to try to find reasonable resolutions to this problem, to take in the public comment, take to account their particular concerns in particular neighborhoods, to hear from the airlines, to hear from the airport, to hear from the FAA and their experts. We're going to continue to take in that information and try to develop reasonable solutions. But it has become crystal clear that the FAA is not being transparent, is not being a willing partner in this exercise, is not being cooperative with the reasonable requests that the city attorney and the city council have made of them. And these lawsuits that we're initiating today will be the next step that's going to be necessary to ensuring their transparency, ensuring their cooperation, and ensuring that we do everything that we can to protect the quality of life in the San Fernando Valley.
Thanks, Paul. And just to make it easy for me, the other city council member here also is named Paul. Paul Koretz represents the 5th council district. Mr. Koretz.
Thank you, Mr. City Attorney. This is an important day, although not a happy one. It's never a good day when the city feels obligated to sue another branch of government for not doing its job. But after tens of thousands of complaints from our residents, months of meetings that have gone nowhere, and a seeming lifetime of empty posturing from an agency that sees airplanes, not people, as its constituency, we don't have much choice. I think those of us in city government all understand that the FAA sees its official role as being that of overseeing an orderly, efficient, and safe national aviation system. Preemptive federal laws, congressional actions, and aviation industry influence all combine to make sure that the people who live anywhere near any kind of airport are treated as second and sometimes third-class citizens. The airplanes and those who operate them, those are the only first-class citizens in that equation. Aviation laws are designed to insulate the system and the industry from local oversight. The only nods they make to residents and local officials are so laden with bureaucratic and wheel-spinning procedures that it's almost impossible to accomplish anything without litigation. The one time I can recall that Los Angeles got a win from the FAA was made possible by a lawsuit the city of Naples, Florida won regarding banning noisy Stage 2 jets. That made it possible for us to do the same thing at Van Nuys Airport a decade ago, an accomplishment that made a difference until takeoffs from Van Nuys were rerouted last year. That set off a torrent of protests, added to similar rerouting of takeoffs from Burbank Airport that now both bombard the hillside neighborhoods especially with constant blasts of noise from planes not very far above them. And now we've got hundreds and thousands of valley and hillside residents in a rage, and appropriately so. This is forcing people to move from their homes and sell their homes. It's literally breaking up marriages and families. In a perfect world, we wouldn't have airports surrounded by millions of residents, wildlife, and other incompatible uses and neighbors. In-city airports are convenient for those that use them, but constitute a colossal nuisance for those who live around them. Our world, however, isn't perfect, and there's not much we can do about that. We don't have all our airports out in the desert somewhere with high-speed rail to get to them. We have airports right in our midst. And we should have a reasonable expectation that the FAA will take that into consideration instead of regulating them as if they had no neighbors worth any consideration at all. So here we are suing the FAA to do the right thing, to take remediation and act instead of spewing out red tape and making excuses. Our task force meetings have been nothing if not shockingly disappointing. We have at several meetings and in writing offered hundreds of questions, and the FAA, at our last meeting, the FAA was there to answer those questions, and their presentation answered nothing. It was absolutely shocking. We need help at both Van Nuys and Burbank airports, and it's time to use the legal system to do it. I thank City Attorney Mike Feuer for acting decisively, Paul Krekorian and my other Valley colleagues on the City Council for working together to seek protection for our constituents. The aviation industry takes care of itself pretty well, but the people on the ground are being victimized many times every hour. In fact, I've had conversations with people in the hills where literally every single minute, maybe with a 2-minute break once in a while, it sounds as if planes are in my living room when I listen to the call from their end of the line. We can't let this continue to go on. I'm glad we're turning up the heat on our residents' behalf, and I particularly thank City Attorney Mike Feuer for taking this action today.
Thank you, Paul. So we have Spanish language TV, yes? Yes, so let me say a few words in Spanish, just a very brief set of remarks, and then I'm happy to take questions. Los residentes de todo el sureste del Valle de San Fernando y las montañas de Santa Mónica han puesto el grito en el cielo por el aumento del ruido de los aviones que salen del aeropuerto Hollywood Burbank. Hoy demandamos a la Administración Federal de Aviación. Estamos luchando para obtener ayuda para decenas de miles de residentes y empresas que han sufrido la peor parte del aumento del ruido de los aviones y otros impactos. Pedimos al tribunal a que ordene a la FAA que vuelva a los patrones del vuelo anteriores y divulgar información sobre el tráfico del aeropuerto de Burbank que el público ha tenido derecho a ver durante mucho tiempo. Okay, happy to take questions.
With this filing, why not include Van Nuys?
So Van Nuys Airport is, as you know, one of the auspices of LA World Airports. LA World Airports has been working with the FAA. My office stands ready to continue to work with LA World Airports on that issue.
I just want to be clear, you guys are talking about all flights out of Burbank affected by this southern shift?
We're talking about flights from Burbank Airport. There's a runway 15 in particular which has been impacted, and we're talking about the flights from runway 15 that are departing from Hollywood Burbank Airport.
And so which are the neighborhoods, or give me an idea of the parameters of the areas most impacted?
I think southeastern San Fernando Valley and the hillsides adjacent to those neighborhoods.
Like Studio City?
Yeah, I think Studio City, parts of Sherman Oaks, parts of, that territory, and the hillsides immediately adjacent to those neighborhoods.
And Paul Krekorian, you said that, the FAA had acknowledged this shift, but then at the same time, you guys are saying the FAA won't acknowledge what's happening? I was confused by that.
No, they'll acknowledge that the flights have moved southerly.
Okay.
According to their calculations, by 1/3 of a mile, the flight trends have moved southward. Our consultants, the airport's consultants, indicate it's more than that,
Oh.
that it's a mile or more, but they do indicate the southern shift. And one of the reasons that this is so important is that, first of all, that moves flights into areas that have never really experienced airport noise in the past. And that's a critical point to the need to do environmental review, because it's impacting neighborhoods that have never been impacted by noise. But it's doubly important because many of those neighborhoods are hillside neighborhoods. And as Mr. Koretz pointed out, that means that the airplanes are literally closer to the homes because the homes are on the hillside. You also get an echo effect from the canyons, which again, the FAA has acknowledged in fact happens. You do get an intensity of noise in canyon hillside neighborhoods. So we know that this is happening. They admit that it's happening. What they won't come to grips with is why it's happening.
And Claudia, I purposely read a couple excerpts of what FAA actually said, and those excerpts are also contained in the lawsuit that acknowledge this southerly shift. But again, there's a real disconnect between the acknowledgement that the planes are moving farther south when they depart in a way that, again, was not assessed from an environmental standpoint. But secondly, the FAA, when we demanded that the flights return to their historic patterns, as I mentioned, says, well, we don't really know what's going on here. It could be flight pilot capability, it could be weather, whatever. Every factor besides, oh yeah, we control in the air traffic control system, we control how planes take off. And that's why I read the quote from the Supreme Court years ago. This effort to distance, to disclaim any responsibility for what's going on is the antithesis of good government. Let's be clear, the FAA should be working for all of us. The FAA, if it were doing its job properly here, would be saying, we recognize that there has been this southerly shift. We are intensely focused on the problem. We recognize that there is an issue for the people who live beneath these flight patterns. They are as much our constituents as anybody else. We should be here aggressively finding out what's going on and taking a change and making a change. And that to me is what, if I were an FAA, that's what I'd be doing right now. This lawsuit is designed to restore the previous flight tracks, and I would hope in the meantime FAA would become a much more collaborative agency when it comes to working with local officials who have constituencies that have been suffering without relief.
Los Angeles isn't alone in this, right? There are communities across the country experiencing
Right.
similar situations. Is there any precedence for a city attorney lawsuit like this actually making any change in terms of Metroplex in the neighborhoods?
Well, I will say, this lawsuit is different from lawsuits that have been filed before. There were some successes. I think Phoenix had some success in litigation, for example, with the FAA. I mentioned, filed a lawsuit with regard to air traffic into LAX. We were involved in a mediation process with the FAA. I was hoping that would get somewhere. That mediation process has not yielded the results that I'd hoped for, but you can imagine that the FAA wouldn't have to see itself as losing a lawsuit. In fact, there's nothing about the filing of this lawsuit that would prevent the FAA tomorrow from taking unilateral action to provide the relief we're talking about. From tomorrow, sitting down with the air traffic control team to identify ways to alleviate the problem immediately. And that's the kind of FAA that ought to be governing the skies.
Is there a higher volume?
All right.
Is there a higher
Paul wants to say one quick thing.
So on the previous question about the FAA claiming not to be involved, I would say if it were more gradual, it almost might be a plausible defense. But I know from year to year attending an HOA backyard party where the previous year it was completely quiet, and then the following year we were being buzzed by airplanes every couple minutes. And I asked, what the hell is going on? And that's when I first heard about this problem. It's very dramatic. From year to year to go from nothing to constantly having planes overhead. And the planes being overhead drop the level of helicopters because they have to be at a lower level. So the people are being buzzed by helicopters when they go by. It's just gone to a completely unlivable situation, and it's not plausible that it could have happened without FAA policy driving it.
So Patrick, then Mary, please.
Okay, thank you. And both Mr. Koretz and Krekorian have touched on this, why there's special concerns about over the hills. But if we return to the pre-2017 situation, why doesn't that just shift the burden back to over the valley and it becomes a zero-sum game?
Well, so I'll say something, and then I know my colleagues want to say something too. When I have been speaking publicly about these issues, I said something, and Mr. Krekorian said something very similar today. Any traffic issue, be it air traffic or vehicular traffic on streets, poses some similar questions, because there is the traffic. The question isn't whether it exists, it's where does it go? And the approach that I think the city ought to be embarking on is we should be sharing the burden across a wide swath of territory so that no one is disproportionately impacted. We recognize that airports are necessary in our region and they're here to stay. People our residents use those airports. It isn't just tourists or others who use them. The question then is, how do we appropriately share the burden across a swath of territory so that the intensity of the noise issue is not focused on a particular group of people to their detriment almost exclusively relative to others? And that's an approach that requires collaboration with the FAA to achieve that result. But in the meantime, returning to the historic patterns, which were patterns that did not give rise to this tremendous number, hundreds of thousands of complaints, makes sense as the FAA ideally works with us to identify what that dispersal approach would look like. And my colleagues may have others that we can say.
Yeah, I do indeed, because my district is a big district, and different parts of the district are impacted differently by this. It's not just the southern shift that's the issue here, it's the intensification. And this is not limited just to Los Angeles. This has been an underlying problem, a fundamental problem that communities across America have faced as the FAA has attempted over the last 30 years to move towards NexGen air traffic control and whatever its predecessor programs were called. But for 30 years, they've been working towards this goal of narrowing the pathways in which air traffic moves across America through GPS controls. And every time they have moved in that direction, a community has been dramatically impacted by that intensification. That's why you have members of Congress who for 30 years have stood up on the floor of the Congress and demanded changes to NexGen. It's why there has been so much resistance to this expansion. I think that is one of the reasons that the FAA has been so recalcitrant in this case, because they know that cooperation with us here will open the door to the need to cooperate with more communities. Well, I hope that it does, because there are communities across America that are being unfairly targeted by this intensification of noise. So it's not, that's why I said at the outset, it would not be acceptable to me to simply move the same intensified noise to another neighborhood. When the city attorney refers to historic patterns, the historic patterns were much wider. It's not just that they've moved south, it's that they were much wider before, and every neighborhood shares in some of the burden, and no neighborhood is unduly compromised.
So basically that's...
Because you say you want the southward drifting flights compressed to their historic patterns, yet you don't want intensification.
No, Maren,
Just clarify that.
Yeah, sure. You used a word that is actually not accurate for us. So it's not that we want them compressed in a different way. This is Paul's point. We're trying the historic patterns were more diversified so that no neighborhood was grappling with the intensity of noise that currently is being borne by the residents of the southern part of the valley. So you have it shared across a wider swath. A number of people are bearing with some noise as opposed to a lot of people bearing with a lot of noise.
So the historic patterns,
Excuse me, excuse me, thank you. The other point I would make is, while the historic patterns weren't perfect, the logical thing to do if we were trying to improve them would have been to start from that as a point of departure and then try to make it better. Instead, we've created the worst possible policy. We've gone from the historic patterns, which were not generating very many complaints. They weren't ideal. My chief of staff lives in the area, but nobody was wildly complaining about it. You went from a dispersed pattern, mostly in the flats, to an intense freeway over the hills. And the hills are a particularly bad place for flights because of the nearness to the flights themselves, impact on wildlife. It's making it virtually unlivable. The logical thing to do would be to go back to the historic paths and then see how we can make it better for the residents and more dispersed, not to look at where we are now, which is the worst possible place, and try to make changes from there.
And to do that
But
with
before,
fire.
can I just say, just really quickly, so to be very clear, when it comes to the litigation that we filed today, what we've said is when the Metroplex analysis was underway, the feds had conducted an environmental review. That environmental review assumed the historic paths would be taken from that point forward. It turns out that the FAA has conceded that has not been what's happened on the ground. So from a legal standpoint, and it's not just a technical legal issue, the historic patterns should have been the place from which an environmental review began if they were going to change them. There was no such review. So the current flight patterns have not been subject to an environmental assessment. Had they been, you can imagine, just based on the complaints that have come up, there would have been thousands of comments made to that environmental review. So it isn't just our effort to unilaterally change flight patterns. It's an effort to say there was no environmental review done of the flight patterns that currently are in place. That's wrong. Return to the status quo and then conduct the review while you have that former status quo underway. Then change it. Don't change first and then study later, if at all. Go ahead, please.
Thank you. Councilmember Koretz, so, but from what we've heard from the FAA, returning to the historic spread out flight paths is basically calling for an end to NexGen, Metroplex, GPS. Is that the core issue, is calling for a total change to this national policy?
Well, I'm not sure that that's correct, but I don't know that I would object to an end to this national policy because I believe it's planes over people everywhere in the country and not taking the impact of local communities into account at all, and just planning for the convenience of the airlines and their flight patterns.
I want to add to that, because that is the response that you would expect from a career bureaucrat whose mission it is to accomplish this bureaucratic goal. But the truth is, the changes that we're talking about probably impact the first 15 seconds or 30 seconds of the flight. For the other 8 hours of the flight, or however long that is, NexGen might work perfectly well in the highways of the sky, but not in the first 1,500 feet of altitude, leaving the airport. That's where the impact is being felt.
And I do want to say just one thing before you do that. I'll speak for myself. I represent the city of Los Angeles. If it turns out that simply asking the FAA to abide by the law, which is conduct an environmental assessment before you make a change, rather than have a change that was never studied. If the consequence of a lawsuit is that, then so be it. If it turns out that that requirement to abide by what we allege the law is requires FAA to rethink something elsewhere, well, that's for another day. For today, I know this much. We have tens of thousands of residents who have been suffering an undue burden that they never anticipated from noise and other impacts from flights departing this airport, and that impact has intensified greatly in recent years. I know that the FAA has acknowledged that change. I know the FAA didn't study that change before it was put in place. I know the FAA has attempted to disclaim responsibility at all for any of that change. And I know that gives us one option. If the FAA is going to work on it collaboratively with us, which we've attempted to get them to do, it leads us to have to go to the courts and get the court to order the FAA to do what it has not agreed to do through discussions with us. That's where we stand. If the chips fall elsewhere down the road, that's for another day. I know, 1, 2, please.
Yeah. Are you concerned that your office is being used essentially for an act of NIMBYism here? because we do have some people that live in Studio City and elsewhere that are dealing arguably with far less noise than people in Inglewood and South LA deal with on a daily basis.
Well, again, to be clear, as I mentioned, we sued the FAA over flight patterns over the West Adams neighborhood and similar locations a few months ago. We've been trying to work with the FAA since in a collaborative way through mediation to get a resolution that would generate a change that balances whatever FAA's needs are with the quality of life below. That hasn't worked, we're continuing to litigate. Now we're turning our attention to this issue on the valley side of the hill. If you were to ask people who live there, because I have in public meetings, you're not saying the airport shouldn't exist, right? People would say, no, we recognize the airport should exist. But they are saying that this unstudied shift has been unfair to them, and we allege they are right. This is not to say, and again, you're not hearing from any of us that one particular other neighborhood should bear a burden that these folks are bearing. We're saying go back to the status quo before and evaluate in an appropriate way with meaningful public input and scientific analysis what the best approaches should be. That's not NIMBYism, that's good government. I mean, I'm sorry, I made a mistake. I'm gonna go here and now, I promise. Go ahead, please. Okay, well then, right on.
Just real quick, could you talk about what the FAA used to justify its either denial or redactions or anything in your FOIL request?
I will say the FAA has said very little to justify that, and that's the point. There are two FOIA requests in play now. One that we just filed, and then there is another one about which we sued today. The one about which we sued, as Paul mentioned, we had actually appealed the FAA's refusal to provide the documents that we believe we're entitled to. And instead of at least processing that appeal and ruling on it, crickets, nothing. So we find ourselves in a position of having to resort to the court for documents to which the public is entitled.
And just real quick, when did you file those FOIA requests?
In 2018.
Oh, okay.
Yeah, October 2018. And those are the ones that are giving rise to the litigation that we filed. And then we filed on December 11th, we filed another set of FOIA requests.
Thank you.
Yeah.
So we've had 4 task force meetings so far and 2 more slated. Why move forward with the lawsuit now, rather than wait for the task force roundtables to be over with, and to add to that, you know, the FAA is also working on an EA on waypoints to kind of mediate this issue. Why go forward now rather than?
Okay, so let's take those questions just in reverse order because I remember the last part first. So, yes, the FAA, only because of pressure from the people you see standing here and others, acquiesced in doing, an EA means environmental assessment, in doing an environmental assessment of prospective changes. We're talking about changes in departure paths that occurred as a practical matter already. The fact that the FAA has agreed under pressure to do an environmental assessment of what's going to happen down the road, that's great. Let that be so. It might take years for it to do that. There's a problem right now relative to changes that occurred already. So that study, the EA thing, is great in itself. We demanded that it happen. It has nothing to do, really, with the effective issue we're talking about now. As for the task force, and again, my colleagues definitely need to weigh in regarding the task force, but I will say this much speaking for the city attorney's office and for me. If I felt as though the task force was making concerted, specific, concrete progress toward resolving these issues, I might have held this lawsuit, however legitimate it is, in abeyance. But that concrete, specific progress has yet to be shown. Now, I will say this. There is nothing about filing this lawsuit that in any manner impedes the FAA from intensifying its collaboration at the task force. In fact, quite to the contrary. It might lead the FAA, because frankly, none of us believes that the best way to resolve a policy issue is through litigation. This is a step we're taking because we think it's necessary, not because it's optimal. The optimal approach is to have the FAA deeply involved with us, teaming up, get in the bottom of it, and trying to balance competing considerations in a meaningful way. So let the FAA intensify, step up its efforts in the task force right now. Litigation, no litigation, that's what good government will look like. My colleagues.
All right.
I think that sums it up very nicely. We're gonna continue our work with the task force, and there's 2 meetings slated. If it takes more than that, so be it. We'll continue on. But the point of this task force was to get information from the FAA and to build consensus among the communities about how we can create a resolution to this. We have not gotten information from the FAA, but I am hopeful that, especially with the filing of these actions, we'll have a more cooperative environment towards reaching an ultimate resolution that reflects a consensus of the people of the valley and also meets the needs of air traffic control. That will be the goal of this task force to achieve, and there's nothing about the filing of this litigation that impedes that in any way. I hope that it will expedite it and encourage it.
Was that last meeting the tipping point? I mean, I know that you and
Well, I have to respond to that. The first few meetings, I think, have been quite good. We've had presentations from different community groups and individuals. The makeup of the task force is good. We have representatives from US senators, members of Congress. We have local council members, ourselves. I think we got a good picture of the problem. And we asked some honestly great questions. I think there were literally hundreds of them. What I thought was devastating is we've been waiting month after month for the meeting where the FAA was going to respond. And they responded with a video that showed the different paths that different flights took. And so one was in one color, one was in another color. And the conclusion was, it's complicated to run all these flights. Well, that was great information that we already knew, and they actually answered no real questions for us. So I thought personally that was devastating, and I think while I have some hope for the task force, and it's great to have a dialogue because at least they are hearing the reality of the impact on hundreds of thousands of people's lives. Whether they would respond without the lawsuit, I'm very skeptical.
Thank you very much for coming and for enduring FAA 101. This session is now done. We'll be available, obviously, individually for other stuff. And colleagues, thank you very much for the deep level of collaboration on an extremely important public policy issue. Thank you, everybody.